Hey friends, in this video, we're going to talk about whether you should wait until your parent becomes a U.S. citizen before he or she files for you if you're an adult who have overstayed in the U.S. I'm going to answer a couple of questions that I get from you guys all the time about this process. The first question is, well, will it be easier and faster if a U.S. citizen parent did it versus a green card holder parent? And then also, will I be able to adjust my status so that I wouldn't have to go back to my home country for a visa interview? But before I get into it, thank you guys so much for watching this video and for sharing my videos all over the world. Really, I really appreciate what you guys are doing and how you're spreading the good word. If you have not yet subscribed to this channel, go ahead and do so right now before you leave today, and hit the notification bell so that you'll be the first to get notice of my videos each week. I'm attorney Latoya McBean Pompey, an immigration lawyer in New York, but I work with clients all over the world on complex family and business immigration matters. Contact us at McBean Law at 516-866-3900 to discuss how we might be able to help you, or you can book your consultation online at any hour of the day at McBeanLaw.com. Let's have a chat about this process because it can be very confusing for many people. So is it really better for a U.S. citizen parent to file for an adult child who have overstayed in the U.S.? Now, when I say adult child, I'm defining that to mean someone who is 21 or older. You may have your green card holder mom or dad, and you're just waiting until maybe they reach the point where they could naturalize and become a citizen. Or if they've had their green card for a really long time, you're trying to convince them to hurry up and file for citizenship so that you can start your process. Whether your parent becomes a U.S. citizen or not does not change the fact, or it will not change the fact, that you are still not going to be considered an immediate relative of a U.S. citizen. Immediate relatives of U.S. citizens are individuals who are children who are under 21 and unmarried. They're also parents of U.S. citizens and a spouse of a U.S. citizen. That's it, guys. Just those three groups are considered immediate relative. If you're here in the United States and you're out of status, and you've also worked without authorization, you're still going to face the same consequences as others in a similar situation, meaning that you are going to need a waiver at some point in order to get through and finish this process and have the green card in your hands. Also, you're going to be in the family preference category no matter what, right? If your parent's a U.S. citizen, you're still going to be in the family preference system. If your parent is a green card holder, LPR, you're going to be in the family system, which means that you'll have to wait. The visa is not going to be immediately available to you as it would an immediate relative of a U.S. citizen. Now, the second question is, well, will it be easier and faster if a U.S. citizen parent filed for me? You're still going to need a waiver, the waiver that I mentioned earlier, because of unlawful presence. Again, this video is for those of you who had overstayed in America or have overstayed in America. So you have unlawful presence on your record, and you'll need a waiver to deal with a bar to your re-entry. If you were to leave America, you're going to be barred for either 3 years or 10 years from returning. And so to get over that issue, you're going to need a waiver before you leave America, of course. You'll still need to also consular process. Go to a U.S. embassy for an immigrant visa interview. Again, this is all under a U.S. citizen parent. You'll have to do all of these things. The other thing I want you to consider is the visa bulletin. There are two tables on the visa bulletin that you should pay very close attention to. The first is Table A, which is the final action table, which shows which green card applicants have priority dates that are current and ready for adjudication. Whereas Table B, dates for filing, which means those of you who are here in the United States, you can now apply for adjustment of status based on the date on this table. And those of you who are abroad, you can submit your documents to the National Visa Center. And again, just a reminder that green cards will not be approved until the priority date is current under Chart A or Table A. For F1 category, we see that the government is up to the adjudication date of December 1st, 2014. Now, if we jump down a little bit here to the F2B category, which is the category for adult children of green card holders, we see that they're adjudicating those cases a little faster. They're up to September 2015. Okay, so that's really important to keep in mind here. That category, the F2B category, is actually moving a little faster than the F1 category. Is it better to be in F1 versus F2B? Not really. Okay, not really, particularly with respect to the speed of adjudication of the applications before the government. People usually ask, well, if I'm here in the US already, I'm an adult, I'm over 21, and my parent has filed for me, can I do adjustment of status? Well, you may have heard me say before that firstly, you cannot do adjustment of status if a visa is not immediately available to you, meaning your priority date is not current yet, and you have not maintained a lawful status. You must be able to show that you've continuously maintained a lawful status in order to be eligible for adjustment of status. If you have maintained that lawful status, let's say you're here on F1, student visa, you're still enrolled in school, you plan to continue your education for the next several years or however long your application is pending for the green card, then yeah, you can actually adjust your status when your date comes up, when the priority date becomes current. Just to summarize, is it faster, easier, better to wait until your parent becomes a US citizen to start the process for you? And my answer is actually no. Start now. Start now when your parent is a green card holder. Get in the queue. It's going to be a lengthy wait anyway, at least 5 or 6 years before your priority date becomes current. So get in line and don't wait, because there really is no true advantage to waiting until your parent becomes a US citizen. Friends, I hope you found this video helpful to you. This was a chat. Comment below. Let me know your thoughts on this one. Be sure to also share it with other people. And guys, I will see you in the next one. Bye-bye.